All right, so let's talk a little bit about franchises. So what comes to mind when you think about a franchise? What kind of businesses do we think about? Fast food, essentially, right? But actually, franchises are more than that. We'll see that chain-style franchising is one type of franchising. So in your reading, were you surprised to find out just how many businesses actually, how big a segment of the economy franchise businesses are? 15% of sales. I mean, that's huge. 700,000 franchises. So again, it's a significant portion of retail and manufacturing business. So I think it is significant that we spend the time talking about franchises, and we'll talk a little bit as we get into this about the advantages and disadvantages. We'll see that there's a lot of restrictions, a lot of contractual agreements that you enter into when a franchisee decides that they want to have the franchisor's trademark name and so on and so forth. So what are some of the pros and cons? We'll talk a little bit about that as well. But before we do that, right, anytime we sort of go into any new area of the law, we like to define who the parties are, right? It's not, we just have to have terminology. And luckily, the terminology here is relatively simple and relatively familiar. So what is a franchise? Well, of course, a franchise is a business arrangement. And actually, I will say it is a contractual arrangement, right? Between, as we'll see, a franchisor and a franchisee, it's where one party basically through a licensing agreement for the most part, because you're looking for recognition, right? Someone said McDonald's and all of these other things where you're looking for your business to have instant name recognition. And in order to do that, you have to agree that you will use that intellectual property in the proper way. So, right, the right to use a franchisor's trade name, trademarks, commercial symbols, patents, copyrights, other types of intellectual property in the distribution and selling of goods and services. That's what a franchise arrangement is all about. The two primary parties in a franchise, of course, are the franchisor, the corporation, well, I shouldn't say corporation, it could be any type of a business entity, but the party who grants the actual franchise or the license to franchisees to use under a established contractual agreement. And who is the franchisee? The party, the local McDonald's owner is the franchisee that has licensed the McDonald's name, the trademark, and so on from McDonald's Corporation, the franchisor. Yes. Can I make the slide bigger? Yes, I can. I don't know how that happened. Apologies. Good reminder. All right, we sometimes see these diagrams and we sort of see the same thing. The franchisor is actually giving a limited license and entering into an agreement with the franchisee to, again, use intellectual property, which, by the way, includes trade secrets as well, right? The know-how of what has made a franchise business such a success is the know-how that the franchisor is passing along to the franchisee in a limited sense and to use in a limited way, as we'll see in a minute when we talk about the importance of that contractual agreement that we're talking about. Okay, now let's talk a little bit about the different types of franchises. And when I asked a few minutes ago, when you think about franchises, what do you think about? And most people talked about chain-style franchises. And we'll get to those in just a minute because we as the public are much more familiar with chain-style franchises. But of course, there are other types of franchises. And again, a little bit more terminology. We'll talk about examples of each of these. A distributorship franchise. The name kind of says it all, right? This is a way to distribute goods. So this is an arrangement where the franchisor actually manufactures the goods, the products, and licenses the franchisee to actually sell them, to distribute them. So when you think about, the easiest example to think about a distributorship franchise is to think about automobiles, right? Most cars, for example, in this country are manufactured where? State of Michigan comes to mind still for the most part, right? So let's say there are plants out in Detroit that manufacture a bunch of cars. Well, we know that we're not going to drive all the way to Detroit to go buy an automobile. We're going to go locally. So there are lots and lots of retail outlets, distributorships that will ultimately, dealerships I should say, that will ultimately sell these cars to the public. So that is that's sort of an example of how a distributorship franchise, not limited to just automobiles, but that is the, classic example that comes to mind, where the franchisor has products that it manufactures. It doesn't have necessarily the know-how or the ability to retail and to sell it, and then there is a way in which it can have franchised operations do it on its behalf. So that makes sense. Another type of a franchise is something called, again, the name says it all, a processing plant franchise. Well, if you have a processing plant, you're obviously making something, but it's the what you're making and how you're making that defines this as a franchise. So what is this? This is where the franchisor provides something, the real know-how of how to do something that is known, that is immediately recognized by the public, and for which there is already an established market for. So you're telling the franchisee how to do it. You're in fact giving them the formula, and the word secret formula, if you will, because that is intellectual property. So for example, when you think about food products, something like soda pop, beverages, and so on and so forth. I mean, to this day, exactly what is it that goes into Coke versus Pepsi? Do we really want to know? But in any event, what is it that distinguishes some of these products, and what is it that makes it so palatable and addictive in some ways to a lot of consumers? Well, that know-how, that when I say secret formula, that the proportion in which these ingredients are used is very, very protected intellectual property. But Coca-Cola Corporation is not doing it all by itself. It's actually licensing franchised operations to have bottling plants and processing plants that actually manufacture the product and then ship it off to supermarkets and what have you. So again, that is a different type of a franchised arrangement. Either you have someone that actually manufactures the products and is looking for a retailer to distribute it, or you actually have a corporation that has a number of products, but they are looking for outlets, franchises, to actually process it, manufacture it on a wholesale level, and make obviously a bigger and bigger market for these products. Two other types of franchised arrangements that we should talk about. And the third one, chain-style franchise, is again what most of us are most familiar with when we think about franchised arrangements. And this is where the franchisor is essentially licensing to the franchisee the ability to make or sell its products. The ability to either distribute its service to the public from a retail outlet serving a particular territory. So let's first talk about the products, right? Again, here the thing that really comes to mind right away is food, right? Whether it's McDonald's or Burger King or Pizza Hut or Domino's or whatever it is, and you might say, well, I mean, pizza is pizza. Hamburger is hamburger. It doesn't take a genius to figure out what the ingredients are. There's no secret formula to it. But is there? Haven't corporations done a lot of marketing, a lot of research, a lot of science behind what it is that people, consumers with their evolving and discriminating tastes want over a period of time? And a lot of times what consumers are looking for is familiarity. If we're driving down the road and we see something that we know is going to have established quality versus a no-name type joint, the idea is that most people gravitate towards the known brand and so on. And that's really the reason why, as we'll see in a minute, why these businesses have such popularity. Distribute services to the public. Well, what kind of services? What kind of franchise business that is not actually making a product but is delivering a service? Yeah. Yeah, I mean, it's tax season. We just got through it. Absolutely. Jackson Hewitt. I passed by one today, the UPS store. A lot of these businesses are franchised business, because what they're essentially doing is they have a methodology in place. They have name recognition in place, and they have the ability to deliver consistent products, consistent delivery system, and so on, which is valued by the public, and such that a franchisee is actually, if you're thinking about, we talked about different ways to set up a business. If you're an entrepreneur, right, you have all of these legal obligations, compliance obligations to worry about. But at the end of the day, what's going to make or break a business is whether or not you're going to be profitable. And a lot of small businesses are not, profitable, not because the heart and soul of the business owner is not in it, but because it's tough. And, again, one of the reasons why franchises tend to continue to be so popular is because you sort of have a leg up if what you're selling, what you're doing at least has name recognition, and at least if you're getting the know-how from the franchisor to figure out how essentially to proceed when you sort of go on and do something entrepreneurial. So, again, we'll talk about advantages and disadvantages, but a chain-style business does seem to make a lot of sense for certain types of business owners. And the last type of franchise that we'll talk about is something called an area franchise, and that's a little bit harder to understand from the name. What is an area franchise? Well, an area franchise is where the franchisor is basically authorizing a franchisee to take a particular area, if you will, and sell franchises within that area. And this usually happens when the franchisor is going into a territory that is not familiar to them. And typically when we think about area franchises, we're thinking about overseas markets, right? So, we know that McDonald's has operations all over the world. We know that a lot of these chain-style places have operations all over the world. But entering a foreign country, number one, the laws are different, and you have to abide by local laws. That's one thing. And number two, for example, if we're talking about food, the food tastes are going to be somewhat different. In it, you can't just go with your conventional fast food menu that you have here in the United States and try to transplant that somewhere else in, for example, a Latin American country or an Asian country or wherever, where the food tastes tend to be a little bit different, and you want to be respectful of certain cultures and what you serve and what you don't serve. So here, in an area franchisee, you're actually going to have someone who is local and has the ability to understand those cultures, to navigate that system, and that sort of intermediary party is referred to as the sub-franchisor, right? To kind of stake out a territory, to help the franchisor scope out the products and services that would do well and so on, and then ultimately to go ahead and sell franchises on behalf of the franchisor. So in an area franchise, you're actually introducing a third party, an intermediary, to kind of sell a franchise business. So, sort of the same thing, but a little bit different in the sense that that direct relationship between the franchisor and the franchisee doesn't necessarily exist. Questions so far on the 4 types of franchises?
So, the franchisor.
Yep.
Sub-franchisor.
Franchisee. Right. So I know these names sound, so, who are the 3 parties? The franchisor, think of that, the word parent corporation is kind of wrong, but think of that, we're going to keep coming back to McDonald's for whatever reason because it's the most familiar, but if it's McDonald's Corporation, that is the franchisor. Some intermediary party, ABC, entity in Vietnam somewhere, I'm just picking a country, is helping to set up a business, and they find that, in Vietnam, God, I picked a country that I don't know that much of the culture of, has particular herbs, that I know, in their cuisine, and they're going to, spice up the hamburger to have more cilantro and more lemon and, all of those fabulous spices in Vietnamese, where to go and, what kind of markets, where the local universities are and things like that. That sub-franchisor is actually assisting and perhaps, actually helping to negotiate the franchise agreements with the individual owners in Vietnam, the franchisees, right? Sometimes it helps to sort of talk it out and you sort of understand who a franchisor is, who a sub-franchisor is, and who a franchisee is. And I did all that for nothing because there's a visual right here, right? There's a franchisor, there's someone in the middle assisting, and again, you have independently owned businesses, franchisees that are entered into with various franchisees. The name of the game today is disclosure, right? In this chapter and also in the next chapter when we get into securities law. Sufficient, adequate, not misleading disclosure of whatever the pertinent facts are with respect to something. So here we're talking a little bit about when we see sort of Federal Trade Commission, obviously we're talking about federal law, and we're talking about a federal governmental agency that basically has oversight, regulatory authority to oversee, among various other things, franchising. And sort of the concern here is that you've got businesses that are anxious to sell more and more subdivisions of their businesses, and are they providing enough information, accurate information, to the businesses, the franchisees that they're selling to, such that there is not misleading statements, fraud, and so on and so forth. So basically they have a rule, the Federal Trade Commission has a rule that requires franchisors to make full pre-sale, right? Because you're selling based on what you think is going to be how the business, predictions with respect to how this business is going to run. Pre-sale disclosures to prospective business owners, right? I mean, if you're going to invest in a business, if you will see that to buy, for example, a McDonald's franchise is very, very, very expensive. It runs in the millions of dollars. And another huge franchise business that is very, very costly and tends to do very, very, very well is what I'm looking at right here in the front row, which is Dunkin' Donuts, right? So, I mean, yes, it's fabulous, but the question is, as you're sort of flood the market and as new competitors come in, would an individual Dunkin' Donuts be as profitable as the various others within that state, for example? So again, how do you temper that disclosure? How giddy do you get when you're trying to sell something as a franchisor at the highest price that you possibly can to a franchisee? So it's not so much, is it a good a good business idea or not a good business idea? The question is whether or not there has been adequate disclosure of the good and the bad, painting the whole picture, and that is in the hands of the franchisor to comply with, to make sure that they're making full and accurate disclosure. The bullet at the bottom of the slide, registration of the disclosure document with the Federal Trade Commission before its use is not required. Why have that random bullet there? We weren't even thinking about that. Well, if you read the next chapter, which I'm sure everyone did, of course, we're going to talk about securities law, and we're going to talk about when companies sell their stock to investors. What we'll see there is that before you do that, you have to register with the SEC. In fact, you have to file a registration statement, right? So these rules or these concepts are somewhat related to one another, but they're separate in the sense that, yes, there is this requirement to make disclosure, but there is not this requirement to necessarily file anything. You have to make sure that you're doing it right, and if there's an investigation, if the FTC investigates, or if you're sued or whatever, that you have to be able to produce it, but there's no requirement that you pre-register any of this. All right, so what is it that you're disclosing? It's a business, right? So you're really disclosing figures and numbers and data. So, and again, you're selling a business in a particular part of the state. There is no Dunkin' Donuts there, right? Not yet. That's what you're trying to sell. So you're not going to be able to say to a prospective franchisee, if you open up a business on 123 Broad Street, Hillside, that it's going to have that kind of sales. So some of this is going to be projections based on a best guesstimate, and some of it is going to be, well, we have other franchises that are, this is their revenue, this is their sales, this is how much they're taking in, and so on. So first of all, there's disclosure of sales or earnings based on actual data. So that means for projections based on actual sales, income or profit figures of an existing franchise, it's not going to be exactly the same because, for one thing, it's not going to be in the same area. If it's not in the same area, then it's not the exact same population, and so on and so forth. But here are examples of this franchise business in a neighboring town, that's sort of services the same sort of population, and so on. And again, there you have to give number and percentage of actual franchises that have obtained such results. So you can't decide that for example, within 10 miles of Newark, there are however many towns, and let's say there are, 5 other franchise businesses, right? You can't just pick the 3 most profitable ones and leave out the other 2, right? This has to be based on actual data, an average, the good and the bad, because that is your actual data. Those are existing businesses and so on. And by the way, a lot of cautionary statements are required. And you'll see the words 12-point bold-face font or type everywhere, because that's under the rules. Why? Because, we as investors sometimes get giddy too when we read glossy statements, and we want to read or we want to believe what we want to believe, and we want to read what we want to read, and we're going to look at the numbers and so on that seem most favorable, but you have to almost steer people to some of the precautions. Hey, past results, for example, are not a guarantee of future results. And you want to say that not buried somewhere, but you want to say that in a minimum 12-point font. Why? Because the smaller the font, the less our eyes are likely to go there. And number 2, you even want to call it out more. The government is requiring you to call it out more by just making it in bold print. Right? So again, making sure that investors have not just accurate information, but conspicuous, obvious, not hidden information. So that's actual data. But if I'm buying a business as a franchisee, I also want to know, well, I'm going to buy the store on 123 Broad Street. There has never been a Panera Bread there before, but I know that there are, picking these names out of thin air, another type of franchise business, but there are 5 others within a 10-mile radius. I've already seen the numbers on those, and they look pretty good. But how do I know what my Panera Bread is going to do here in this particular area and so on? Well, the franchisor here is going to the extent that they're forecasting. Well, what are the assumptions? How many other sandwich shops are in the area, right? Here versus there, because sometimes your competition might drive how much sales and how much profit you might have. What are the percentage of actual franchises that have obtained projected results? In the past, when the franchisor has made its hypotheticals, how successful were they? How accurate were they, and so on? And again, cautionary statements. These are just projections. There's no guarantee that if we're thinking that sales are going to exceed 10,000 based on the fact that Rutgers University is within, a 5-mile radius or so on, that you can expect more students to come, and so on and so forth. I mean, these are just educated guesses, but that's all they are, right? So again, a lot of disclosure, good disclosure, not fraudulent, not misleading, and more importantly, complete disclosure in terms of having a franchisee make an intelligent, hopefully, thought out business decision on whether or not to invest in that particular business. And there's more, and again, just to give you a flavor for all of these Federal Trade Commission rules, you might have to also have other types of statements appear on the cover of and oftentimes, has anyone ever seen a franchise disclosure? Oftentimes I'll find someone in a class that says, well, I looked into a 7-Eleven once or something like that. These are glossy, sort of almost like a prospectus when you're buying stock in a company and so on. I mean, and, they're online and so on and so forth. Again, on the front covers, hit them everywhere so they see that there is risk associated with potential return as well. And by the way, the disclosure is not just mandated at the federal level. It could also be mandated at the state level, and we'll get to that in, I think, the next slide. Oh no, here it is, state disclosure laws. And again, please don't memorize the names of these rules. I'm just giving you a flavor for the fact that there is also a requirement which may go a little bit further in some of the states in terms of what kinds of things, how they must appear, and so on. So if you're selling a business in New Jersey, you might have more state disclosure than, for example, if you're selling that same business in the state of West Virginia or something like that. So, as a business entity, you have to not only comply with federal disclosure laws, but also pertinent state disclosure laws. Have you had enough of disclosure for the moment? Okay, we'll come back to it in the securities law chapter. Now let's talk about the arrangement itself, right? So, after proper disclosure has been made, after the parties have been fully apprised of what they can or cannot expect, two parties, franchisor, franchisee, decide to enter into an agreement to run a franchise business. It's a contract. It's a contractual agreement. In fact, it's called a franchise agreement. And it basically, very importantly, sets forth the understanding of the parties, terms and conditions. It's a voluntary agreement, just like any contract is, the breach of which leads to potential damages and so on. We'll talk a little bit about what kinds of things are in a typical franchise agreement. But the one big thing that we often think about are the rights and ability of the franchisee to properly use the franchisor's intellectual property, whether it's trademarks or service marks, right? I mean, of course, when we think about any of these businesses, when I think about Dunkin' Donuts, I think about that cup of coffee, I think about those colors, I think about the orange, I think about the pink, and again, even, it's just your mind is almost trained, right? And you think about McDonald's, you think about the arches, you think about all kinds of, the Ronald McDonald, whatever. I mean, all of these things are so entrenched, and that is valuable intellectual property that has to be used in a particular way, that cannot be misused in a way that diminishes its value and so on and so forth. So that, you're going to note, is going to be one of the key things that is addressed. What can or cannot the franchisee do with the intellectual property that is the property of the franchisor? What can or cannot the franchisee do with the trade secrets that are being given? We talked about processing plant franchises. They're giving the know-how, the secret formulas on how to make a particular beverage, right? That's under lock and key. And you have to sign all kinds of confidentiality agreements, your employees and so on, that those formulas, the percentage and proportions of these secret ingredients that go in will not be divulged, because again, that's extremely valuable intellectual property, and that's going to be addressed in the contract between the franchisor and the franchisee. And then there's a whole bunch of other things that will go into a franchise agreement, and this is just sort of a quick summary of those things. So we've talked about the actual intellectual property, the licensing of it in terms of how how a franchisee should and not misuse that intellectual property. But there are other things. For example, the initial licensing fee. I call this a down payment. Right? You're going to buy a business, you're going to have to make some kind of a lump sum payment. And by the way, it's much more than a lump sum payment, as we'll see, but what is the initial cost to buy that business? Right? That's referred to as the initial fee. Royalty fees. Now I started thinking about like copyrights and things like that, but that's what that's sort of typically call these things. One of the things that franchisors want from franchisees is a cut. If you're going to have sales of this much, a percentage of those sales come to us. Why? Because we're giving you our know-how. We're distributing to you the ability to have various of these types of businesses, but we want something in return. How much? It's often negotiated based on estimated profits, based on investments, based on other things and so on. But it's not unheard of to think that the franchisor will get 5%, 10% of the actual profits from the sales that are made with respect to a franchise business. So that's huge, right? And one of the perhaps disadvantages of having a franchise business, because you're actually having to give up some of your profits right back to the franchisor. An assessment fee. Anyone want to take a crack at what kind of fee that might be from the reading? When you assess, assessment fee could mean anything, right? But these are sort of marketing and advertising costs that the franchisor, all those commercials that we hear, right? If McDonald's or Dunkin' Donuts or Pizza Hut is running these commercials, where, what are the, yes, they're footing some of this bill themselves, but they're basically taking fees monthly, yearly. They're assessing these fees to the individual franchisees, because together everyone benefits from these. So you're doing that as well. Leasing fees. Well, oftentimes they're finding you a property, an address where they think it's going to be the best place to put up this kind of a business. You usually have, a 20-year agreement to run the business. You don't own the real estate. They do. The company does. Well, nothing is for free, right? The cost, the leasing cost of that real estate is something that the franchisee has to pay for the franchise. I mean, the left-hand side is talking a lot about upfront and ongoing payments that need to be made, that are going to come out of the bottom line. What else? Actually, we're still going to keep talking about money. You're going to run a business, you're going to need supplies, right? I mean, if I forget about food for a moment and I start talking about H&R Block or Jackson Hewitt or something like that, well, you're going to need paper, right? You're going to need printer, you're going to need toner, you're going to need envelopes, you're going to need a packet that you give to clients and so on. Can you just go to Costco and buy the cheapest manila folder that you can buy, right? Keep costs down as a business owner. I mean, I go to my account and I don't get anything fancy or with logos. I just get a manila envelope. No. Again, there is a branding involved here, right? So they would expect you to buy your supplies either from them or from someone that sells those supplies. What kind of grade does a paper have to be? What kind of, what kind of envelope does it go into? What kind of folder is presented? All of these add to the cost, but that is required. Why? Because we want consistent quality product, and the franchisor controls all this. If I come back to the food business for a minute, if you go to any food business, they have, even a napkin has to have their logo, has to have a certain quality, right? I mean, a franchise business can't decide, gee, why can't I just buy the Costco stuff? Well, you can't. You're not running a mom and pop operation, you're running a franchise business, and there is a requirement that the supplies meet a certain standard, and more importantly, that they be uniform and consistent, and even if they come at a bit of a higher price. That's part of the deal. To the extent that you want a little hand-holding, how is it that I can appeal more to my customers? How do I train my staff and so on? Well, that comes at a price too. The franchisor has experts that will help you drive up sales by, understanding how to greet customers, by, training your employees and so on. But those are consulting fees that they will charge you to deliver that know-how, right? Money, kind of has to be invested in these kind of businesses. These agreements will also talk a little bit about the territory, and that's important, right? Because think about it from both sides of the picture. The franchisor wants to sell as many franchise businesses as they can, because look at the fees, that add up, and the name and the profits and the sales and so on and so forth. The franchisee wants to have as big a territory as possible. One of the things, if I am buying a franchised Panera Bread, right, that's the one I said I was going to buy on 123 Broad Street, I want to know, right now, I know that there's not a single Panera Bread within a 5-mile radius. Are they going to sell another one 2 miles away? Because if they do, it's the same exact product. All of a sudden, would I not expect my sales to be compromised as a result? So again, how exclusive is my territory? I may not have a heck of a lot of say in it, but I want to negotiate as big a territory for myself as I possibly can, right? Because I want to have those sales. I mean, I'm already facing competition from the Blimpies of the world and the Subways of the world. I don't want the exact same franchise to be a mile away from me, because now that's truly cutting into my bottom line as a franchise business. Quality control standards. This is huge to the franchisor, right? Again, I mean, I keep harping on the napkins and so on and so forth, but I mean, from everything to how do you keep the napkins stacked? I mean, what is the customer experience when they come in? Because you turn people off to your brand at one franchise business, you've turned them off to your brand as they go visit other parts of that state or other parts of the country where you're in. So exceptionally important to the franchisor is maintaining their quality control standards, and you'll see in various of these agreements their ability to do, surprise visits. Checks tell you what to do. The ability to terminate an agreement if you do not meet quality control standards, because that's huge. It's a privilege of running a franchise business, is to do things their way. and training minimum requirements in terms of who you hire and how well you train them. Because again, the face of the business is the face of the employees in many ways. And they're, an accountant at H&R Block not greeting you in a particular way, not giving you that customer experience cuts into the branding of that type of a business and the quality that they expect people to have, to the experience that they expect people to have should be consistent among their franchises. Again, we can go on and on for a semester talking about franchise businesses. Yes? Sure. Royalty fees. It's not, these are sort of typical things. So when you look at a franchise, the words royalty is used in different contexts and so on. In a franchised agreement, royalty fee typically is thought about as a percentage of the sales. An assessment could be for various reasons. I just gave a couple of examples. You're going to be assessed a marketing fee. You're going to be assessed, all franchises are and so on. That's okay. That's okay if it comes to you. Just, yeah. And question, again, there's a lot here. I'm not expecting everyone to memorize everything, but again, there is a flavor to this that you start to see, which is, again, if you forget the difference between royalty and assessment, it's not going to be a deal breaker on an exam. It's kind of a nitpicky kind of question. But what it does do is it gives you a flavor for the franchisee has to pay a lot of different types of ongoing and initial fees, and they are held to high quality standards, training requirements, so on and so forth. Did you remember your question?
So is this sort of disagreement, is it sort of like a combination of a contract, mortgage, note, like?
No, they could, no, because you could have various agreements. That's a good question. The question is this everything? Is this going to be the lease as well? No. What it is it's this contract is talking about a lot of these things, and for some things this is the only agreement. The training requirement and everything. But, for example, the real estate portion, the lease might accompany this. But within the agreement, you have said that this is a 20-year, for example, arrangement between the franchisor, and it will be governed by a lease agreement appended to this, and so on and so forth. So it will be dealt with here, but, again, you can't get everything into one piece of paper. Again, there's more detail, but I'll go through it real quickly. Covenant not to compete. Anyone know what a covenant not to compete is and how it might factor into or the arrangement? Yeah.
You cannot get into that kind of business.
Right. Right. So everyone heard that. So a covenant not to compete, and it's not just limited to franchise businesses. A covenant not to compete applies in many different contexts. If I was going to work for a company and I'm bringing my stupendous know-how on something, and I work for them for 5 years, they might say to me, don't go to a competitor for a year. Or something like that. And that might be in their interest, and I may have signed off to it. So in this context, it may be that after my 20-year arrangement ends with this fast food franchise, the franchisor is concerned that I'm going to take everything that I have learned and try to mimic it in, they still want to sell this franchise to somebody else, but I'm going to open up a business just like this one, not infringe on their intellectual property, but call it whatever, but make product that is very, very similar and compete with them. So they might say that you cannot open up a competing business within what? Within some reasonable geographic area for some reasonable period of time. Because you can't infringe on somebody's ability to make a living, but you can, a covenant not to compete could be, well, you can't be within a 2-mile radius for 2 years or something like that. That's perhaps reasonable under the circumstances. So you might see that in a typical franchise agreement. Yes? Sure. So what you're talking about, what kind of a processing plant kind of a thing?
It's a food,
Well, see now, I mean, we're mixing up apples and oranges. I mean, U.S. courts are not going to enforce Brazilian law, right? I mean, so that's, yeah, so that's a good question. There is no, because there's something called the sovereignty of nations, right? So yes, there are tribunals like the Hague Court or for dealing with more political issues than anything. But in business law, at the end of business law 1, remember, for example, we talked about international law in general. And yes, you could voluntarily, under an agreement, have your own law that says you will not violate this, and a court will uphold an agreement, but there isn't a quote-unquote law that goes across national borders. It just doesn't, right? So maybe I can flip your example a little bit, which is like, could a U.S. franchisor have sold a business to a franchisee? Now they go off in a different country and kind of mimic the same thing. Well, if they're not using the same intellectual property, that you cannot do. I mean, that would be a violation of intellectual property. But if you're just sort of figuring out how to the know-how of how to run a business, well, nobody can stop you. A covenant not to compete typically has to be limited in its scope. And oftentimes what you're really worried about is coming into the same territory. Right? You can't say you can never open up another hamburger joint anywhere, right? It's that you cannot open up a competing hamburger joint within a 2-mile radius because, we trained you, we invested in you, and we don't want you competing against one of our franchises. Yes? If an employee doesn't sign non-compete, well, this non-compete is typically not for the employee, it's for the franchisee. I mean, unless we're talking about intellectual property. I can't go and work for McDonald's, right, for example, for minimum wage, and I'm not saying that I can't go work for a competitor, right? But if you're talking about intellectual property, for example, if I work at a Coca-Cola plant, okay. Okay. Sure. Yeah. It's quote unquote legal. I mean, it's not, we'll talk about ethics and legal in a minute. But yeah, I mean, one of the requirements of the job is that we stay profitable, I'm looking at it from Bally's standpoint. So the question was, could Bally's fire a personal trainer? Because, what if he opens up his own Jim's Gym? Well, that's a good name. And competes with Bally's. And the thing is, hey, if we're giving you a client list that, by you working here and so on and so forth, and you decide to leave us, and that's the exact example that I sort of gave. Like, if I go for a company and I could be terminated if because again, a business has a right within a limit, now you can't say you can never open up a gym anywhere, ever. That's not reasonable. But to say that you cannot open up your own competing gym for a couple of years within a 5-mile radius is a reasonable thing. And if you're not going to sign off, adios. And sadly, but that's, it's business, and that's how it is. A few other quick, yes?
Well, you said the clientele list. I was just wondering, like, for realtors, I know when they work for a company and they want to leave, they have to leave all their clients for the company. That would be the same.
It's kind of the same thing. I mean, you're transporting different ideas from different types of businesses. But, so the question is, if you work for a real estate company, and you've built up a roster of people, one of the requirements of Century 21, I'll just pick them, is that sure, you can go work for Weichert, but you're not taking our list of perspectives with you, and that's absolutely true, because to a lot of these types of businesses, that list is the intellectual property that's worth so much. So that's absolutely, and there's a lot of litigation over these types of things because you're balancing the fundamental right of individuals to earn a living against the legitimate rights of a business. And you can't get overzealous in something like that, but what you're describing is typical. Arbitration clauses are typical in all kinds of commercial agreements today, and all they say is if there is a dispute between the parties agree that they're not going to go to court. And you might say, what? You're depriving me of my right to go to court? Isn't that so un-American? Well, I mean, no, you're agreeing to arbitration. And arbitration, from those of you that I think everyone said they've taken business law one already, is another way to resolve a dispute. And it is legitimate, like Supreme Court has said, that there is nothing that you're necessarily giving up if you voluntarily agree to arbitration instead of having to go to court. It saves money, it saves resources, so on and so forth. So you'll see that. How long is the arbitration agreement for? I'm sorry, how long is the franchise agreement for? How long? Is it a 10 year, 20 years? I mean, a lot of that is going to depend on what is your lump sum investment and so on. It's a thing of negotiation. It's not something that is, every franchise is 5 years or 10 years or 15 years. It's however long that is negotiated. Any other terms of conditions, what is the total investment and so on. A lot of monetary concerns, but also a lot of other types of things. So, you get a flavor. It's complicated. It's very individualized to the type of business and so on and so forth. I mean, it wouldn't be business law if we don't talk about liability, right? Liability. We worry about that. We worried about it so much when we talked about business entities. We were so worried about it when we were talking about personal liability and so on. But now we've got two distinct entities, don't we? We've got this master, I don't want to call it a parent, this master corporation up on top that is entering into a franchise agreement with a bunch of different franchisees. And let's just say that everyone is doing the right thing. They're existing independently. And by the way, how do you set up a franchise business? What type of a business entity can you be? Do you have to be a corporation? Do you have to be an LLC? Do you have to be a partnership? Whatever, right? You decide how you want to do it and so on and so forth. So, you have those concerns. But the question really here is that could the act of the franchisor make the franchisee liable, and vice versa? Could the act of the franchisee make the franchisor liable to third parties, right? That's the liability we're talking about. And the answer is, look, for a properly organized and operated franchise business, the franchisor and franchisees are separate legal entities, right? They have distinction among them. They're McDonald's Corporation and Franchisee LLC are two different entities. One store here does in some ways represents a business, but their liability is not the master corporation's liability. So a franchisor deals with the franchisee as its independent contractors. They're both separate entities. So what that means is franchisors are liable for their own contracts and torts, and neither party is liable for each other. That is a general rule, and that should not be surprising. However, there's always some gray, right? So let's talk a little bit about, well, this case was really just applying the general rule, wasn't it? This was the Domino's case, 2010, from Maine. And the question was, can Domino's, the franchisor, be held vicariously liable? Remember that word vicarious, meaning we didn't do it, but one of our agents did it. Could that make us liable for the negligence of its franchisee? I'm tired of talking. Who wants to talk now? Quickly, what happened in the Domino's case? Yes.
Domino's was, of course, the franchisor, and PDPO was the franchisee.
Right.
And somebody from PDPO had a car accident while delivering, so the customer tried to sue them, the one that got injured. And so Domino's on the case, they were not liable.
Well, but who did this individual that was sued, who did they decide to sue?
Both Domino's
Exactly.
and the individual independent contractor.
The franchise business, yep. And what did the court say?
That Domino's won the case that they were not liable because they were independent contractors.
Well, so everyone's hopefully heard that. So, you've got Domino's, the master corporation, and you've got a franchised Domino's business outlet. Now, we all know when we order pizza, and this used to be more of a bigger deal a few years ago, but wasn't it like, if we don't deliver in 30 minutes, your pizza is free kind of business? And I think there's backing away from that, because think about it, you're putting a lot of pressure, and I know this wasn't so much in the case, but I think we can kind of read into that possibly the hurried nature of having to make that delivery in the right period of time kind of could possibly lead to negligence on the part of the individual driver. So an accident happens. But the question is, well, who's responsible for this accident? And assuming there's insurance and all of that other stuff, obviously plaintiffs like to go for the deeper pockets. And here, yes, TDBO, whatever the name of this independent franchise was, has assets, but who has even more assets? Well, Domino's Corporation has more assets. Why not sue them too? And say maybe it was your policy of 30 minutes and it's free that perhaps led to this. And the court says no. Here, the negligence was, if there was any negligence, and perhaps there was, driver could have been looking at a tax, the driver could have been driving too fast, or accidents happen, right? Whatever the case might be, you're not going to hold the, Domino's Corporation liable. The acts of the individual franchisee are their own torts and their answer for them. This is the general rule. Unless we see something, the court says, that leads us to think that the franchisor should have been liable, we are not going to break the general rule and pull them into the tort liability of a franchisee. Okay, it's applying the general rule. Now, let's apply an exception to that general rule, and this was the McDonald's case out of Illinois. And there's not a heck of a lot on this slide, because all the slide says is McDonald's Corporation liable for negligence? And this was a pretty sad case based on its facts. Briefly, what happened in the McDonald's case? Kim, is that a hand?
Yeah.
I'll help you.
So they determined that there was this McDonald's in this area, and they determined that they needed to have more security. So they came.
Who's they?
The corporation.
Yeah.
The franchisor, I guess you could say. And so they came in and determined that they shouldn't put garbage out after a certain hour out the back door. They should go through the side door. Different types of security.
They should maybe have a lock on the back door,
Yeah.
alarm maybe.
I'm not sure if they never went over it with the employees, or the employees did.
They didn't.
do it.
They didn't do it.
They didn't do it.
Right. So basically, McDonald's Corporation came in, talked to the manager of a particular franchise business and said, this is a crime-ridden area. We have a concern about some of our franchises that are in particular areas, and these are the kinds of steps you should be taking. You need to take, actually. In fact, McDonald's Corporation, as we read on the case, had created this whole safety division that basically was responsible for doing this. So they gave them the advice, which included, don't put garbage out, as you say, from this door versus that door, especially when it gets dark. Put safety locks, get an alarm system installed, and so on and so forth. And they went on their merry way, and they never came back. But what happened?
So then the back door was left unlocked one night, and a guy came in and 3 employees.
Well, there were 6 of them, but yeah.
And while moving, actually shot one of them.
Yeah, and really injured the other 2. So there was a lawsuit, and the lawsuit was on behalf of these, and they were kids. They were teenagers working one night at a McDonald's, and their parents sued not just this business for negligence, for not protecting employees while they were in the workplace, by simple steps that could have perhaps avoided this situation, but going one step further and saying McDonald's, the parent corporation that doesn't run the day-to-day business of this operation, was also liable. What did this particular court say?
They were liable.
Yes. And the question is, well, how is this case different from Domino's?
They had a whole program.
Yeah.
set up for them, so they knew.
Well, they said, look, it's, McDonald's entrenched itself in the policies of its franchisees. In fact, exactly, that they had a whole division, understanding, so, and requiring that certain steps we take, and then not following up and not seeing that those steps were taken and so on. And that, in fact, made them negligent, as negligent as the franchise business, such that it is now possible for McDonald's to incur this liability. Now, of course, that just means that they can be sued. Now you have to go to court and prove all of this. But, this is sort of the exception to that rule. Yes?
If they wouldn't have been involved, if they wouldn't have done security department, if they wouldn't have showed up,
Then I don't think there was liability. That more than, from what I know from the facts of the question is, what if McDonald's, we know that there are stores in more crime-ridden areas versus others, and what if in this instance this didn't come to light? They didn't the answer probably is no, there would not have been. They kind of injected themselves, and you might say, well, why do they do that? Well, because how are they going, if this becomes, it was hurting their reputation too, right? So they had a corporate interest in doing that. We'll talk about corporations and their benevolence when we talk about in the last chapter. Oftentimes it's the right thing to do. And the other reason corporations become involved is, my God, their brand name is going to be hurt. There are a bunch of robberies at McDonald's and they didn't take steps to deal with it. So yeah, they entrenched themselves, but they did it for a business reason as well. And guess what? Not doing it half-heartedly actually cost them. In this particular law. So not just cost lives and suffering, but it also costs them economically. And then there's another sort of thing that was in the book, and that is, well, what if the franchisor didn't really do anything as obvious as what McDonald's did in this case, which is to go there and, talk about security and so on. But what if, the franchisor actually creates an appearance that somehow the franchisee is pretty much connected to it, even though they're actually kind of independent entities. Could you be liable in that case? And here there wasn't really a text box case, but there was an example. And the example was Holiday Inn and a bar. And it just sort of, Holiday Inn, by the way, hotels are independently franchised by Holiday Inn, the massive corporation. And, the facts of the case real quickly were, again, we're talking about an area where there perhaps is a little bit more crime, and we're talking about a bar and a restaurant and drinking, and that often is a combination of or something happening. But what happened here was there was a parking lot situation. Holiday Inn Hotel didn't have enough parking, and there was this bar, and it's in everyone's interest if people come to these businesses and so on and so forth. So what happened here was that Holiday Inn franchisor allowed signs, their hotel signs, to be posted, not just at the hotel, but at the neighboring bar. And what happened was there was some security people hired by this franchise business, but the security people were not great because one of the security guys was drunk on the job and the other one was a trainee, and unfortunately, sadly, some altercation happened and people got hurt. And those people that got hurt sued this business for not protecting them, for not having adequate security, and number two, they also sued Holiday Inn. Now you might say, well, Holiday Inn, the franchisor, didn't have anything to do with this exactly the way they did in McDonald's. But the reason there the court said that there was apparent agency such that the franchisor could be liable was simply by the fact that a third party, a reasonable third party, could think that, hey, I'm going to a bar, it's called the Derby Bar, something like that, I just read the case this morning, and there are all kinds of like posted signs, Holiday Inn, you have a certain expectation of security, a certain expectation of the way things are run. We expect the Hiltons, the Holiday Inns to provide. So if you're going to allow your intellectual property to be posted this way, and we have to assume that they did in this case, then there could be potential liability that comes out of it because third parties could legitimately and reasonably assume that you were going to provide adequate protection to patrons that came and not just stayed at the hotel, but also went to the neighboring adjoining bar, restaurant, or whatever this was. So yes, the general rule is that franchisor franchisees are separate, but if you inject yourself too much into the business of a franchisee, or if you allow this apparent kind of agency to happen because a reasonable third party could believe that there is a connection, there could be a potential liability to the franchisor. all good things must come to an end. Termination of an agreement, right? This is a contract. It's not forever. It runs for a period of time. So usually, franchise agreements permit a franchisor to terminate the franchise for what? For cause. I would even say for good cause, for valid reasons, right? So unreasonable strict application of a just cause termination clause constitutes wrongful termination. I'll explain that in a minute. Termination at will clauses void on the ground that they are unconscionable. Okay, so think about it. I'm a franchisee and I have invested $1 million, $2 million up front, and I'm paying all those royalties fees and assessment fees and so on. And, yes, I am bound by the various terms and conditions of the franchise agreement. And we have a 20-year deal, right? The question is, can my agreement be terminated early? And the answer is, well, it depends. You cannot unreasonably take a clause and apply it in a way that it would be unfair to the franchisee. A couple of times, maybe, there was an inspection, and it is possible that the inspector from McDonald's noticed that my employees did not cheerfully greet the customers, that they didn't, whatever our protocols were, they didn't offer, and so on and so forth, and that really hurts our business, and it's part of quality control. And, they were warned, and the second time it happened again, and that's it. Agreement terminated, right? Now, is that fair? Of course not. That's very strict application because, again, this is not some egregious act. This is something that needs work, and it might be that you impose a penalty. It might be that you require mandatory training. It might even be that you insist that the franchisee fire this, whatever the case might be. But to terminate an agreement based on that would be wrongful termination. Why? Because this is an agreement that has, millions of dollars of investment in it. That's not just cause, The other thing that these agreements cannot have is termination at will. Termination at will means that the franchisor can cancel the agreement for whatever reason. Is that fair? Well, even if somebody negotiated that, that would be completely unfair, right? We've talked about at will before when we said employment is at will, which means you were talking about your friend at Bally's, right, who was terminated. Well, the reason I said that that's okay is because it's employment at will, But to say that at the will of the franchisor, we don't want you anymore, well, that's, this is a financially complex arrangement. You can have agreements that are terminable on good cause, but termination for not good cause, not just cause, is something for which the franchisee can sue the franchisor for, because termination has to be for valid and pressing reasons.
Like is it franchisor is going bankrupt, something like that? Terminated when
Well, I don't know. I mean, there could be more to that. I mean, when I hear bankrupt, remember, I think about somebody is going bankrupt. Are the financial reasons something that have been negotiated into this? Sometimes bankruptcy, as we've sort of talked about earlier in this class, doesn't mean that you can terminate an agreement. It just means that now there's an automatic stay and the court decides that. So I'm not sure that is a valid reason for agreement. I think what is, for example, if you're looking for what is a valid reason is a habitual, constant, ignoring of quality standards after much back and forth. It could be very simply not paying on time. So maybe you weren't thinking bankruptcy, maybe you were saying the franchisee is not making the royalty payments, not just 1 month late, 2 months late, it's habitually late, right? Those could be valid reasons. But you can't look for a very strict application. It has to be, you got to give time to cure, to fix, if you will. Sure.
What if the business is just not making any
Which business?
The franchisee is not making any money. Can they go to the franchisor?
Excellent question. We looked at all the disclosure. We had a different understanding. What do you think?
Franchisor can
I mean, unless there was fraud.
Say yes or no?
No. I mean, if I'm just going by what the facts would dictate. But in the disclosures, bless you, there was not any fraud or misleading statement. Unfortunately, sometimes things just don't pan out. We had expected the Panera Bread to do fabulous, but guess what? The median cost of living in this neighborhood just doesn't allow folks to spend $10 per sandwiches. And all of a sudden the market took a dive too, and people are out of work, and unemployment rate is now 10%. I'm going back to 2008, 2009. And that's when I was in that unfortunate situation when I bought this business. Is that enough for someone to just say, yeah, you could go back to the franchise, try to negotiate, obviously voluntarily, but to say, I need an out, no. I mean, there's no valid reason for that. And for example, that could be a breach of an agreement, right? In order to terminate an agreement, you need valid reason. And there may or may not be. But if not, it is a breach of agreement, and a breach of contract is like anything else. Either party has a cause of action against the other party. And, it sounds unfair and so on. But again, this is the cost risk analysis, the due diligence that needs to be done when you are taking on any kind of business. Because why is a franchise different than if I just rented space from somewhere and I go to my landlord and say, I can't pay the rent because my business is not profitable? Well, too bad. I rented to you for a 10-year lease.
So what if there's an anticipated freeze, right? And the person finds somebody else that's willing to do
Sure.
everything.
But the franchisor has to agree to it. Did you agree to some assignment or not? It's possible.
So if they say no, and you're going to lose all your money.
Right. And oftentimes parties will negotiate, and if you think back to contract assignments, oftentimes, a reasonable assignment should be something that, what if it's on a what if that franchisee has a health emergency or something that they simply cannot? It was an owner-owned mom and pop type of thing. No can do. Terminal illness or something like that. And I found you someone who is an equally good credit risk. It would be unreasonable withholding of, these are very common disputes that happen all the time. And you kind of have to look at it from the same lens of contract law as you would for any other kind of a contract. So it's an excellent question. And then we'll sort of wind up this chapter with what is at the heart of a franchise business. It's basically a licensing agreement, right? It's a business arrangement where the owner of intellectual property, whether it's trademarks, trade secrets, whatever, is licensing to another property. Licensing meaning subject to terms and conditions, the ability to use that intellectual property. So you can call the franchisor a licensor, and you can call the franchisee a licensee. When you have a license to do something, you have set parameters within which you can do that in. And I don't think we need a diagram to tell us that. We already know that. All right, there was no other place, I think, to put this material, so there are a couple of leftover concepts in franchise chapter, and that is, because we've talked about all these various ways in which business enterprises can be formed, right? And we've talked about limited liability and all of that. Well, what about two entities wanting to do something together? A joint venture. We read about it in business news and so on and so forth. Happens all the time where two businesses come together, not because they want to merge, as we talked about, or combine, but simply because they want to pursue a single project. And this used to happen back in the day, and maybe it still happens with electronics companies sometimes, a Sony and a Panasonic wanting to do something together. They're not merging, but they're sort of taking their know-how and combining together to perhaps come up with this next biggest and best electronic advance or whatever that might be, and that's fine. But the question is, thinking about how these two entities should do that together. For example, they can form a partnership. A joint venture partnership is a partnership owned by two or more different joint ventures that are going to work on a single project together. Okay, sounds good. Or you could have a joint venture corporation, right? A corporation, a separate corporation that is going to be operated and created simply for this joint venture purposes. What's the difference between a partnership and a corporation when you're doing a joint venture, and why is one better than the other, perhaps, from a strategic standpoint? Say that again? Liability, right? Right? The magic word of the day. Absolutely. Why? Because, they're both going to invest capital in whatever this idea is. Some ideas are successful, some are not, and so on and so forth. What happens in a joint venture partnership is that both entities are liable for this entity's torts, negligence, contractual obligations, and so on. It's not just limited to the capital that they put in. The better way to establish this would be to establish a totally different corporation that is partially owned by both of these entities, because what that does is that they're only liable for torts and contractual obligations of this separate entity up to the amount of the capital investment that they put in. Anything more, they're not liable for, because it is a separate corporation, and 1 and 2 are not, quote unquote, personally liable for that. So it's just another way to sort of talk about liability from a partnership corporate standpoint, but we're talking about two separate entities, coming together and running a joint venture. And then there's this sort of little slide on strategic alliance that basically says, look, companies don't always have a formal relationship. Sometimes they basically have a contractual relationship that says we're not forming a partnership or corporation, but we're going to sort of come together and work on something. And maybe this is a sharing of ideas, maybe it's a sharing of cost, maybe it's a way to strategize, maybe it's a way to sort of see if there is something here to work together on before we move to the next step. The cautionary tale here is that this is nothing more than an agreement, right? There is no, maybe this leads to something, maybe it doesn't, but this is not as formal as setting up a separate joint venture entity.